Welcome to Flesh of the God.
All right. Juror number 82, if you would please stand up, and starting with the verdict for John Michael Hakeem Gibson, would you read it from the top, the very top, all the way down, all the way through? Then after that, I'd like for you to read the verdict for defendant Ms. Smith. Start at the top and read it all the way through. And then I'd like for you to recite the verdict for Mr. Tyrone Taylor. Start at the top and all the way through. All right.
What's good, children of the cosmos? The God here, back in a digital temple. And today, we're not just peeling back layers of reality, we're tearing through the fabricated curtain to expose those shadows lurking within the system, designed to blind us. We often speak of unseen forces, the energies that shape our world. But what happens when those in power manipulate the very fabric of our justice to serve their own agenda, or perhaps to secure a public victory at any cost? We're talking about a recent verdict out of Fulton County, a case involving a music label owner, John, aka Cash Out Gibson, and his mother, Linda, Mama Cash Smith, and co-defendant Tyrone Taylor, now found guilty on charges including Rico, trafficking for servitude, and grape.
State of Georgia versus John Michael Hakeem Gibson, aka Cash Out, defendant. Indictment number 23 SC 186464, Judge Marlene Leffridge. Count 1, conspiracy to violate Racketeering Influence and Corrupt Organizations Act, Georgia RICO Act. Your verdict I'm sorry. So now you may start reading the actual.
Yes.
Okay.
Mm-hmm. Yeah.
As a conspiracy to violate subsection A, the Georgia RICO Act, we the jury find the defendant guilty. As to conspiracy to violate subsection B of the Georgia RICO Act, we the jury find the defendant guilty. We the jury unanimously agree that at least one defendant committed at least one overt act. Yes. Count 2, trafficking. We the jury find the defendant not guilty. We find the defendant guilty. Count 12, aggravated. We the jury find the defendant guilty. Count 14, trafficking in person for. We find the defendant not guilty. Count 22, trafficking. We find defendant guilty. Count 23, trafficking in person for. We the jury find the defendant guilty. Count 24, aggravated assault. We find the defendant not guilty. On the lesser count of battery, we, the jury, find the defendant guilty. Count 25, possession of firearm or knife during commission of or an attempt to commit certain felonies. We, the jury, find the defendant guilty. Count 26, pimping. We, the jury, find the defendant guilty. Count 27, pandering. We, the jury, find the defendant guilty. Count 28, keeping a place of prostitution. We, the jury, find the defendant guilty. Count 29, willful obstruction of law enforcement officer. We, the jury, find the defendant guilty. Count 30, simple battery. We, the jury, find the defendant guilty. Count 42, keeping a place of prostitution. We, the jury, find the defendant not guilty. 5, possession of prohibited items by inmate or providing prohibited item to the inmate. We, the jury, find the defendant guilty. Count 23, trafficking a person. We find the defendant guilty.
On the surface, it seems like a win for justice, right? But for those of us who observe the patterns, who understand the games played behind the scenes, there are questions that demand answers. Let's consider. Throughout this high-stakes trial, the public's direct window into the proceedings was deliberately obscured. The live feed gone. Why? Why, when transparency is paramount, why would the very mechanism that allows citizens to witness justice unfold be systematically shut down? It forces us to ask, what didn't they want the public to see? Was it just procedural irregularities? Or was it tactics that, if exposed, might reveal more about the prosecution's strategy rather than the defendant's guilt? We've seen this play before in Fulton County, where their need to secure conviction sometimes overshadows the sacrosanctnicity of the The sacrosanctness of the due process.
For just a second, I'm kind of disturbed because F you, and then somehow that email was CC'd. To me, that never... Mr. Joe, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too, and the reason...
Well, I'm asking you a question. How did you find out about it?
I'm going to answer you the question.
Okay.
Scuttle, if you look at...
No. I'm asking you, how did you get this
I'm
information?
not telling the court. What I'm saying is based upon information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have... I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
A party?
Yes.
A witness? Who witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court,
okay.
Or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said actually all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So
your co-counsel won't even tell me who said whatever. Okay, and the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation.
Concerns about evidence, presentation, and prosecutorial overreach linger long after the gavel fell. The prosecution, in this case, pushed hard, painting a picture of a 7-year reign of terror. And while the accounts of the alleged victims demand our empathy and justice, we, the awakened, must also scrutinize the methods used to achieve that justice. When access is denied, when the public cannot bear witness, the very foundation of fairness is called into question. Bank statements, alleged forced prostitution, testimony of horrific exploitation, these are the grim facts presented. But when the light of public scrutiny is dimmed, when the scales are not visibly balanced, then a verdict of guilty leaves a lingering taste of disquiet.
State of Georgia versus Linda Smith, aka Monica Vinny, and Mama Cash Out. Indictment number 23 SC 186464, Judge Leffridge. Number 1, count conspiracy to violate the Racketeering, Influenced, and Corrupt Organizations Act, Georgia RICO Act. As to the conspiracy to violate subsection A of the Georgia RICO Act, we the jury find the defendant guilty. As the conspiracy to violate subsection B of the Georgia RICO Act, we the jury find the defendant guilty. We the jury unanimously agree that at least one defendant committed at least one overt act. Yes. Count 36, trafficking a person. 2, we the jury find the defendant not guilty. Count 37, trafficking a person. 2, we find the defendant guilty. Count 38, prostitution, we the jury find the defendant not guilty. Georgia versus Tyrone Taylor, aka Ruski, indictment number 23 SC 186464, Judge Leffridge. Conspiracy to violate Racketeering, Influence, and Corrupt Organizations Act, Georgia RICO Act. As to conspiracy to violate subsection A of the Georgia RICO Act, we find the defendant guilty. As to conspiracy to violate subsection B of the Georgia RICO Act, we find the defendant guilty. The jury unanimously agree that at least one defendant committed at least one overt act. Yes. Count 9, we the jury find the defendant guilty. Count 11, aggravated, we find the defendant guilty. Count 13, trafficking a person. 2, we the jury find the defendant guilty. Count 15, aggravated assault with a deadly weapon. We the jury find the defendant guilty. 16, false imprisonment. We the jury find the defendant guilty. 17, pandering by compulsion. We the jury find the defendant guilty. Count 18, possession of cocaine. We the jury find the defendant guilty. Count 19, tampering with evidence. We the jury find the defendant guilty. Count 20, willful obstruction of law enforcement officers by use of threats or violence. We the jury find the defendant guilty. Count 21, pimping. We the jury find the defendant not guilty.
Gibson, his mother, and Taylor left that courtroom in handcuffs. But the question remains, was this truly justice, unmarred by manipulation? Or was it a strategic victory achieved through the tactics that undermine the very transparency of our system claims to uphold and call just? Flesh of the Gods will continue to dissect these complex truths, reminding you that power lies not in controlling the narrative, but in demanding the unvarnished truth, even when it's uncomfortable. Stay vigilant, children of the cosmos. And yes, that was the verdict of Cash Out. Appreciate y'all tapping in. Much love. Stay fresh. Stay blessed. Peace out. Well, hey, if you made it this far, you might as well hit that like button down below. Subscribe and comment below if you would like to see me break down over 80 pages that I have of this full indictment starting back from 2019. Let me know. Peace out.